So to dive in today, thank you everyone for joining. This is our literary law 101, what authors should know about contracts, copyright, AI, and more. I will say there's probably, again, a lot of questions that we could get through today. Joe is our legal expert who I'll introduce. I feel like you're a bit of a unicorn in the industry because we do get the question, is there a legal publishing contact? And we really know how important the work that you do is.
Thank you.
So today we'll talk about here, the author is always the expert on the topic of the book, but what about when it comes to the legalities of writing and the publishing process? So from understanding issues like copyright and fair use, which I'm getting to know more about myself, to negotiating contracts with service providers, to navigating hot topics like AI, many authors quickly realize that there can be some complicated legal issues to face as they're working to get their book to the finish line. So today we are joined by Joseph Perry, attorney at the law offices of Joseph J. Perry, and he's a literary agent as well at Perry Literary, and David Wogahn, author and president of AuthorImprints, to discuss some of the most common legal questions authors ask and to talk us through some of the basics of literary law. My name is Corinne Mulder. I'll be moderating today. I'm the Vice President of Business Development at Smith Publicity. Again, please add your questions into the mix. I came up with a few of my own generated by ChatGPT and modified on my own. So if we have some more time, we'll certainly get into those ideas there. Joseph Perry is a publishing attorney, literary agent at the law offices of Joseph J. Perry and Perry Literary. As an attorney, Joseph counsels clients in the publishing industry, where he drafts and negotiates various publishing agreements, conducts legal reviews of manuscripts, registers copyrights, and helps authors start their own publishing companies. As an agent, he represents best-selling cookbooks, authors, athletes, and musicians. And Joseph obtained his legal degree from St. John's University School of Law and a Master of Arts in English from St. Bonaventure University. David Wogahn, dear friend and savior for so many of our authors who come in and need a little help to the finish line, is the president of AuthorImprints, an award-winning publishing services company that helps authors professionally indie publish books using their own publishing imprint. David is also the author of several books, including the Countdown to Book Launch workbook and the author of the first LinkedIn Learning course on self-publishing. He's a member of several boards, and he sits on the Santa Barbara Writers Conference. Before founding AuthorImprints in 2011, David worked for the Los Angeles Olympic Organizing Committee, the Los Angeles Times, and was the co-founder and COO of the first online publisher of sports team branded websites, known today as CBS College Sports Network. Quite an impressive background for the two of you bring today. And I thought we could kind of get started here with the basics. And the most basic of all is, what is the purpose of a copyright? Joe, can you fill us in there?
Sure. And thanks so much for having me today. I'm really excited to talk to everybody. I love giving Q&As and webinars like this. So thanks. I really appreciate it. So copyright, essentially, it gives you the ability to really enforce your rights as a creator. And under the Copyright Act, there are like a bundle of rights that you get. And a few of those, I'm not going to go through all of them, but like the right to create derivative works, the right to reproduce your work, the right to display your work. So essentially, maybe this gets too much into the weeds here, but there's like two parts to copyright. There's the first part that's really automatic. As soon as you essentially click save on Microsoft Word and you've created something, your copyright is affixed, but you can't really do anything with it to enforce it unless you register it. And that's a really easy thing to do. You can go on copyright.gov. They have a whole tutorial about it. It's pretty cheap, I think like $65 the last time I checked for an application. But once you do that, you could get the copyright to your work. It depends on how much of a backlog there is at the Copyright Office to determine how long that's actually going to take. Could be a few weeks, could be a few months, but once you get it, then you could enforce your rights. So that's really the whole point of it and why everyone wants it, because everyone's infringing works out there. So you want to be able to protect yourself.
Excellent. And David, for the purpose of your work on the publishing side, the copyright date, anything to add there?
I'd say everyone's concerned about that in our world. I'd say maybe half the people will do that. Will actually go through those steps that Joe just spoke about, and I'll tell people as soon as it's in that fixed form of expression, it's formally copyrighted. But as Joe said, it's really an issue if you want to bring suit against someone. I think it really depends on your publishing goals, and some people are publishing just for family or fun or love, that type of thing. But I have worked with some traditionally published authors, and where I see this becoming usually a little more of a concern is the manuscript is kind of going out in the wild, and so they might is it a pre-registration for your
You can,
copyright?
yeah, there are certain limitations to that. For instance, like you have to, you can pre-register something if you think there might be like pending litigation or you think someone's going to infringe it. So yeah, you can do that. But what I also, it's so interesting that you say that because I deal with this too. And questions always is, well, when should I register it? Technically, the law is 3 months after you have until 3 months after publication. But what I say is that, maybe if you're self-publishing, maybe wait until the very, very final version of it so you don't have too many, applications as well. But there's also a group registration as well. So if you have, it wouldn't apply in this instance, but I just wanted to mention this. That if you have, it has to be the same type of work, but if you have 10 articles or even like 10 books, you can have one application instead of 10 of them. So it's a really good time saver and money saver for you. So I don't know if that answers I hope that answers your question.
And well, to also build on that, I think, in the indie world, things can change. It's a little more fluid, I think, with the author changing things. As you just point out, maybe wait until the end. And I tell our clients the same thing too. Even with kind of the formal registration, the final steps of the ISBN and things, there's always something that can come up. And you want to make sure that your metadata, all that information is exactly accurate. I don't know, you might change the subtitle on something. And as Joe says, maybe you have to refile on that. So I think, I would look and say, what's the, the risk profile of this and how many people are going to see it? And, and if you're going traditional, or you're out with maybe, your agent or several agents and you have a higher risk, or if you're a high profile individual, or the topic that could be of concern. But, in our experience, a lot of the indie published works, it is smarter just to wait until that end, but don't put it off, because you do have to have it in place if you're going to bring suit to somebody.
Exactly. Yeah. Excellent. Yeah.
It's really helpful. Thank you. I think for the trajectory of some of where the questions are going, we're definitely going to be diving into using song lyrics and how we can approach individuals to make sure that's fair. But I think before we dive into that, we should hear a little bit more about the term fair use as we're talking about licensed copyright. And Joe, when we were prepping for our webinar, he had drawn my attention to the Andy Warhol case, which was just settled last year. There was an original photograph taken of Prince by Lynn Goldsmith in 1981, which was then licensed by licensed by Vanity Fair in 1984 for a one-time artistic reference. And that artist was Andy Warhol, who did go on to create a full Prince series then based off of that one image that was captured. So it was in 2016 that I believe she found out about the full series. And this was from another publication running a rendering of his artwork. And in 2022, it was settled for the photographer Lynn Goldsmith that she won the case, as the photo was used, inappropriately. So, Joe, can you tell us a little bit about fair use and how that would really skew the copyright conversation?
Sure. I wish I had another hour to talk about just about fair use. It could be quite complex, but the crux of it is Section 107 of the Copyright Act allows you to use certain types of works in certain ways without getting permission from the copyright owner. However, it's very complicated in that it really is a case-by-case basis. You can look up the statute yourself, but it's not going to really do you any good because it's very vague. But essentially, through the case law, through the decades, courts have essentially looked at four factors. And the first factor is actually the most important factor. And that first factor goes towards why you're actually using the copyrighted work. It's called the purpose and purpose of the use. And under factor one, what the courts, at least before Andy Warhol, what they were always asking was, have you transformed the content? Essentially, the whole point of copyright law is to progress the arts and sciences, right? They don't want you to copy and paste something in your work from some other material just because you think it looks cool. That doesn't progress anything. They want you to actually further the conversation. So they came up with this term called transformative use, which essentially transforms the content. You give your own commentary, your own analysis, for instance, your own interpretation, your own like a new utility about the work. So something new that we can all take from that work. How are you recontextualizing it? So if you do that, you're good to go, at least in terms of factor one. But then you have the other three factors. The second one is the nature of the work, and that goes towards what type of work is it? Is it factual in nature or is it creative in nature? And courts tend to protect creative works more so than factual works because it goes towards like the copyright policy, but essentially they look at authors as like these artistic geniuses that they create something out of nothing. So if it's creative in nature, like a novel, a song, that copyright owner is going to have more protection compared to a work that is purely factual. Say like a database, for instance, not sending any trade secrets, but just your run-of-the-mill database. They want that work out there in society. They want facts out there in society for all of us to use. So then you have to look at like, okay, so step two is, all right, is my work creative or is it factual? And then underneath that has the work been published? There's all these sub factors as well. So that's why it gets a little complicated. And courts always want to protect you in terms of publishing your first, they want to protect the publication of your first book, essentially. Where are you publishing it first? That's what they really want to protect. So after those questions, then third is really, I think, the question that everybody thinks about with fair use is how much am I using? And they look at it qualitatively and quantitatively. And there's no real bright line rule. It really is a case by case basis. And just real quick, I'm not going to go through all the details, but there was a case about President Ford, and he wrote a memoir called The Time. I forget the name of it, but anyway, it was about why he had pardoned President Nixon. And essentially, The Nation magazine scooped Time magazine's excerpt of his book. And in that excerpt was only 300 words of why he pardoned President Nixon. However, those 300 words were considered the heart of the work. It was the whole point of why people were trying to buy the book in the first place. So even though The Nation only took 300 words out of an entire book, it was qualitatively wrong, essentially. The court held against them for that reason. So I bring that up just to say, just because you may take a line, 2 lines, 3 lines, it's all case dependent, it's all context dependent. Or should be case by case, context dependent. And then factor 4 is the effect on the market. If you could have licensed the work, that might be a strike against you. However, this is where purpose is sort of tied into the other factors. If you're using it for private use, that's likely not going to be an effect on the market. However, if you're using it for commercial purposes, that's going to be. So essentially, the courts look at all those factors, they add them up, and then they determine if your use is going to be fair. That's a lot of work to do from a court, and especially for a lawyer. So what we try to do is try to predict what a court is going to do. It's not foolproof, but that's essentially what we can do. We could say, well, the court said this in this case, or it said that in that case, and then we try to come up with a strategy to help you, essentially be within the parameters of fair use if you don't want to get permission, because it can get expensive. Copyright owner might not be around anymore. It might be really hard to get the permission, et cetera, et cetera. So anyway, I know it's a long-winded answer, but it is complex. So I just wanted to mention those 4 factors.
It certainly is. And it sounds like there's just a lot of, of room for interpretation.
Yes. Oh, 100%. Yeah. Yes.
We'll probably.
And to bring it back to Andy Warhol. So yes, you have all these things. You're like, oh my God, I'm never going to use anything ever again. I'm not going to I'm not going to do anything without permission. On top of that transformative use, and I should have mentioned that. Now it gets a little bit more muddied in that you now have to justify your purpose. In that within that case, the uses were for the same purpose, to be in a magazine, essentially. So I don't think that the court intended this, but essentially they're saying that, like, if it's for similar purposes, it might not be okay, even if it's transformative. So your purpose may have to be different. So it kind of narrows sort of what you can do as of right now. That's why I'm hoping there's going to be litigation on it, because I don't think that's what they intended, and that might be a result from it. So and again, I'm one attorney giving you this synopsis here about this case, and what's going to happen, sort of prognosticating. So I'm hoping that we get some answers so I could it'll make my life easier and your life easier as well.
Definitely. And I think to bring this into the writing process now with a better idea of fair use in general, and one of the questions here in the chat that we actually wanted to make sure it was addressed today is when it comes to using things like quotes and song lyrics in books, what should authors be mindful of about fair use? And I would love for both of you to weigh in on it. Maybe David, where you come in with the flag of it's time to think through this from the legal perspective, where your limitations end. And then Joe, where you can kind of navigate to just have a few takeaways of what individuals should keep in mind.
Yeah, I'd say that whenever an author says to me that they've got song lyrics, that's a red flag. That's like an automatic red flag. And I'm not saying, I'm not making a judgment call on that, obviously, but what it says to me is that there's going to be a higher risk. That particular form of content is something that is watched very closely, and perhaps because you're going to use some part of that lyrics to what Joe was just saying, that could be a substantial part or the main part of that body of work. And so that may be looked at differently. But I know that in my experience with, I don't know, half a dozen of these, everything from the author contacting the copyright holder and getting an actual license to do this, is extra work. We're having to figure out ahead of time, or they're asking for, what do you think the sales are going to be? And then you get into these reporting requirements that you're going to have to say, well, how many books did I sell? And in order to satisfy, the audit requirement on this. So it just becomes a real can of worms, and it takes longer too. So if you're on any particular production schedule, it's just things just move more slowly. The costs are there, the complexity is there. So, if you can write around it, great. It's not impossible. People have done it. I'd say if you are going to do that, and if it's really critical to your work, then you certainly have to go through that process. And I would get a license for lower numbers, not higher numbers, because you don't know how the book's going to sell. And if you're successful in selling it, then pony up the extra royalties in that regard. It would make a difference. But if you can write around it, it certainly makes your life easier.
That's great.
Yeah. It's such a good point too, in terms of the license. I mean, I don't know how many of you have actually tried to contact the copyright owner, but it can be very complex. They ask a series of questions. What's your print run? Where is it going to be printed? In what languages is it going to be printed? You may not even know that information yet. And the print run may be too small for them. Who knows? They may not want to be, associated with a book that's, maybe a couple hundred copies. I don't know. Maybe they do. But yeah, it's such an interesting question. I do legal reads all the time in terms of song lyrics, and so there are ways to get around it. You can always include things that are in the public domain. Everyone here, go to Duke University's Public Domain Day. I believe as of now it's 1927, like before 1927. Is in the public domain, but just great resources. Just if you ever want like a quote at the beginning of your chapter, use Shakespeare. It's in the public domain. And what I always say, at least for novels, I mean, is make it up. If you're it depends on what the book is about, but I always say, if you're making up everything else, you might as well make that up as well. And then in terms of like song lyrics, like that's just one example. I think a novel, and then juxtapose that with you're writing a music biography, say of your favorite musician, your favorite band. At least in my opinion, you could more likely include the song lyrics if you're commenting on them, you're analyzing them, you're essentially recontextualizing them. You're essentially doing scholarly work about these lyrics. That's the whole point of fair use and copyright law. So I think that's sort of like a good example to say like what might be okay and what might not be okay in terms of song lyrics, at least from what I've seen. Have you? What about you, David? Do you have anything else to add?
No, it's I agree with all that. I'm usually the one that gets the phone calls, to try to figure out how many copies are we going to sell, and we sit there with a spreadsheet and kind of estimate out, and and everybody's going to be different. I mean, to your point, that's yeah, you got to first find the person that has those rights, and that's a piece of work as well.
Yeah. It's a lot of time. It's not to say that you shouldn't do it or can't do it. It's just, I just feel it's just a pain in the butt for most people. So it's a way
ask yourself how critical. I think the analogy of the sort of the music kind of focus book and doing the analysis on that versus some lyric that's going to set up, it's like a epigraph or something in the book or something that's illustrating a point in the book, and I think you could probably write around that.
Yeah.
And we tend to think that, the reader's really going to care about that greatly. I think we care more about it than the reader does necessarily. So if you can get away with doing that and just paraphrasing or, referencing it, they can, go look it up on Spotify or Apple Music.
Exactly. That's what I ask my clients all the time. How necessary is this to your book? And are the readers really going to care about? And yeah, and you can paraphrase, you can get around it. With copyright, it protects the exact expression of what you're taking. If you write it in your own words, it's a way to get around. But of course, you have to cite to it, but it's a way to include that material without actually potentially committing infringement.
Yeah.
My head is already spinning.
Yeah. It's a lot to think about.
It's great stuff. And I guess, for the purpose of the writing process where I feel we're kind of moving the webinar through phase 1, phase 2, right? I don't think there could be any more connected or intimate work than a memoir. That is someone's personal story. We can't get it wrong, right? To the best of our memories, but you had both brought up the memoir and the legalities around memoir in terms of what authors should look out for when it comes to libel, especially when writing a memoir. So can you explain a little bit there, Joe, as you're nodding along, what authors do need to consider? And David, would love for you to jump in as well around that.
Sure. So mainly you have to, in the legal reads that I do, I mainly do it for a few things: copyright infringement, trademark infringement, libel, and right of privacy. So libel is essentially a false statement of fact about somebody that essentially ruins their reputation, or they believe in their eyes it ruins their reputation. And just saying that something is my opinion doesn't automatically make it go away. You could say Joe Perry is an alcoholic versus I think Joe Perry is an alcoholic. I could still sue you for defamation, for libel, because that's not true. So what you need to understand is that there are different standards for public figures and public officials versus everyday people like you and me. The public figure / official standard is actual malice. It came from the case of New York Times v. Sullivan. Maybe some of you have heard of it. It gives a lot of leeway for us to write about public figures and public officials. It's a high bar that they have to climb in order to prevail in terms of defamation. Now, with private individuals, it's much easier in that all they have to do is prove that the statement that you wrote was that you were negligent in writing that statement. So it's much easier to prove. And then there are also things that are essentially what are called libel per se statements. So, for example, if you claim that somebody committed a crime and they didn't do that, that's a classic example of that. So there are all these statements that you have to think about, especially if you're writing about everyday people. So, and I'll get to right of privacy in a second. But what I always try to do is counsel clients in saying, well, how good of a relationship do you have with these individuals? Can you get release forms? Can you have them sign releases? If not, that's when it's sort of, all of this is one big risk analysis, from copyright to liable to right of privacy. So it's all context dependent. But if you don't have a good relationship, or you don't think someone's going to sign something, then that's when you really want to be careful, especially if you're writing something about somebody it's a private individual, or excuse me, private, not public, official or figure, and it might be potentially libelous, and that they might come after you. If you don't think they're ever going to come after you, that's one thing. But if you think they might, that's when you really want to tread lightly. And then there's right of privacy, which you could still write something that's true and still get sued for it. So if you are publishing private facts about somebody that they would deem offensive, they can come sue you. The classic example is like someone's sex life, for example. They don't want that out there in a book, and you're publishing it. They can sue you. And then there's another form of right of privacy is false light, which is essentially the same analysis as libel. You are portraying somebody in a false light. So, for example, calling a doctor a quack, that doctor's methods have killed someone, and that's not the case. And then there's the classic one, which we all think about, like the paparazzi and someone hanging from the trees and taking pictures of everybody. And then lastly, there's name, image, and likeness, which has come to the forefront. So in getting releases, I always ask clients to get releases to not only allow them to limit their liability in terms of writing about people, but also to make sure that you get it, that release includes that person's name, image, and likeness. The reason why I do all of that, and I should have mentioned this to begin with, is that libel and right of privacy are state-based. So every state has its own set of laws. However, they're I shouldn't say so similar, but most of them are very, very similar, that you can sort of decipher what a privacy claim is going to be and a libel claim is. That's why for my legal reads, I generally just do I do like a general read, because you technically could be sued by anybody. I don't know who's in your book. Someone might be from Texas or Wyoming or Oklahoma. So it's one thing for me to say, oh, it's under New York law, here's what it says, but I just do it as in a general level, because technically you can be sued by anybody. But those are the things that I think you should sort of be aware of. So I don't mean to scare anybody with all of that, but these are the things that I wrestle with on a daily basis.
Wow. Anything to add there, David?
Not a lot. I'd say that, not that our business is a proxy for this industry, but we just don't deal with a lot of these kinds of issues. I think the average person, and I think Joseph's comment about, everything's a risk analysis, that's exactly the way I look at it too, is that, that and the golden rule. I mean, what's your point of writing these things? Are you really trying to drag someone under the bus? And you probably should be careful about that. But in the few projects that we've done, I think the thing I'd add is the attorneys are usually looking at the context too. So whatever that statement is, and then what's the surrounding material for that statement? How is it being set up? Mm-hmm. So this contextualizing all that is really critical when you're doing the review. And I think for us thinking about that, that's probably a good way for us to think about it, as well as, what's my point here? What am I really trying to say with this? And do I have to say it this way? So you can probably get yourself out of a lot of hot water by being a little more reasonable.
Yeah,
exactly. It's all context dependent, and that's exactly what it is. I'm looking for the language itself, but also how is it set up? What is the surrounding material? Oh, and just very quickly, because I just saw a question here, it just reminded me. Mm-hmm. You can be sued for writing a novel. Not to say that just because you put on your cover a novel, that automatically means it's not going to be libelous. You still can be. So in that instance, excuse me, and I mentioned this for nonfiction as well, there are things you can do. Create composite characters. Don't base it on one person, base it on many traits. Change names, change identities. You want to essentially de-identify that person. However, it's a catch-22 sometimes, because you're like, well, if I write about this person knows it's him or her. Like, they're going to know. So in that instance, that's where you sort of want to think about the risk in terms of what you're writing about, because there's two parts to it. It's will that person know it's him or her and come after me? And then B, what evidence do I have because the truth is a defense, but you need to have like documentary evidence, and it's hard because who documents their lives on a daily basis. You're living it, right? So that's where you sort of want to take that risk analysis and think like, okay, is this thing really really necessary for me in terms of getting my story out here? And I deal with this all the time with memoirs, people going through some really really tough things. But is that specific thing that you're writing about that person? Is that really, do you really want to get hung up on that? What's the point of your book? Your book is probably, it's about your life. It's about your story. So don't forget that. And I guess I just try to sort of spin it with a sort of the positive and thinking about the whole purpose of writing the book, and don't get hung up on this sort of, it's not to say that you can't write it, but I see that a lot of times. And I just, if you have to take it out, it's okay. I'd rather you publish your book and enjoy the publication process rather than get sued and regret that you wrote it in the first place.
Yeah. Thank you, Joe. That's so helpful there. And we are seeing a lot of comments and questions in here. I do think it's time to jump into AI a little bit, since that's certainly.
Can I just answer one question? Sorry, I just saw this one here because it goes.
Please, Joe, go ahead.
Yes, I think it'll help a lot of people. Libel and right of privacy only deal with people who are alive. You can write about people who have passed on. Yeah.
Another one for you.
Sorry, so continue.
Yeah, no, that's fine. So I think, we had gotten into discussion a little bit with David's comment before we started on AI generated material versus, AI generated human modified. What are some of the things that, you're seeing, Joe, that are changing the legal landscape when it comes to publishing, in terms of things to start looking out for? And David, as a part 2 to that, I would love for you to jump in as well on something you mentioned, which was vendor considerations around republishing, as well as it relates to AI.
Well, I mean, obviously that's the big thing. That's the elephant in the room, right? With artificial intelligence, and we were mentioning this in our session beforehand, but it's really at the forefront. The Copyright Office wrote guidance surrounding this. You can go look it up for yourself if you would like. I think it's like a 15-16 page document. And essentially what they say is that if you use artificial intelligence to create your materials, but you don't sort of do your own thing, essentially modify it. If you just create it and pop it out and then boom, that's it. That's my creation. I'm going to put it on Amazon. That's not going to work. You can't register your copyright. There has to be some human intervention. And that's the whole thing with copyright law. My next point doesn't really have to do with artificial intelligence, but there were copyright registration questions about like, well, I was taking a picture, and this actually happened. This guy was taking a picture, and somehow this monkey pressed the button on the camera and created this picture. And the question was, well, can a non-human author register a copyright? And the answer is no. You have to be a human to do that. So it's sort of interrelated with artificial intelligence, where they want that human interaction. They don't just want it to be, computer generated. So, but that's really all we're at right now. I mean, I know there's tons of lawsuits that have been filed, but it was mentioned to you, Corinne, before today, the FTC came out and said that artificial intelligence will be within its purview in terms of like copyright infringement, outside of the Copyright Office. But they're essentially saying that if you're doing this and you violate copyright, it might be a consumer protection issue as well. So that's something to really look out for. So I just think we're at the phase right now. We're still like, everyone's wondering what's going to happen. And I think I'm hoping that the Copyright Office will come up with something soon, so we can have some more guidance rather than, oh, it just has to be human generated, because there's so many different questions surrounding that. But that's really where we, at least where we are and what I'm seeing in terms of like the big changes, in publishing. So.
Yeah, I guess what I would add is there's been a lot of focus on the generation aspect of things. And what I noticed when Amazon, maybe some of the attendees already know this, but within KDP now, there's actually a question you have to answer every single time you input content about whether or not you've used AI tools in creating any of the text or any of the imagery used for the cover or inside the book. And I think it's interesting how they divide it up between the AI generated and AI assisted. And so you don't have to tell them about AI assisted. AI assisted is when you're when you've created the content and then you use AI to enhance it, right? Or what's happening in publishing now, is you find a lot of publishers, and self-publishers too, can use AI to, help you. You can think of some keywords, you put it in, it gives you more keywords. Is a very, simple example, or you put in a bunch of titles and here's some other titles that you come up with. So it's helping you be more creative, which I think is something that's going to be a big time saver for a lot of people. It's already been in use, and it's been in use for quite a while with it. But in terms of that vocabulary, I think it's helpful to kind of divide it into those two things between assisted and generated.
100%. Yeah.
That's really helpful. And how can authors, this is mirroring a little bit here, how can authors protect their work once published, knowing the tools and the capabilities of artificial intelligence, new platforms being developed all the time? Is there a way to safeguard once it's actually out there?
I guess the thing that you could do is, depending on, who you're creating it with, or if, you're traditionally publishing it, for example, you could put language in the contract that nothing's going to be, you're not going to use artificial intelligence to create anything. That's, the Authors Guild has I think a sample provision. You can all go there at the Authors Guild's website. You can put it in your contract. So I would suggest putting that in collaboration agreements if you're with somebody, because that's the question, right? Like, how do you know what somebody has or hasn't created? And you don't want to be on the other end of that potentially, it was infringing when you didn't think it was.
Right.
I think also I would add that for those, here today, just asking when you're a very simple thing, when you're asking for quotes on things, or you're working with a publisher, whatever, maybe asking, is there anything that's been created using artificial intelligence, or I need to know about that, or how will my material be used? If you have concerns about those things. So I think disclosure is pretty critical. It's becoming more important as we go forward too. And that's, I think, what's behind some of the things on KDP is you need to be forthcoming about how it was used, because you don't want to kind of find out after the fact, or get in trouble somehow that what you did use and you lied about, and now you could actually get kicked off the platform.
Exactly.
Right.
Or worse.
Another good question here about AI is, how can authors prevent their books from being used to train AI and other learning machines without permission from the copyright holder? And I think that actually goes to the Sarah Silverman case, right? That was open with some of the authors who had come forward claiming that their manuscripts were being used to train to train different AI systems. So is that where the law is still catching up, Joe? Or okay.
From my understanding, yeah. So I wish I knew the answer to that, but I'm hoping I can come up with something.
And I can understand, especially for those that are independently publishing, these are really important questions to be asking. For the purpose of contract, is there anything in there that you wanted to bring in with the AI clause in the Authors Guild, Joe? I think that was something we did start to talk about that I could see maybe being beneficial to our registrants today.
Yeah, like I mentioned before, essentially any relationship that you enter into, I would put that contract, or excuse me, that provision in the contract, especially for collaboration, agreements. It might already be in, well, I guess it's publishing, it's written by the traditional publisher, so it might not be in there, but I would include it in there. Any ghostwriting agreements that you have, freelance agreements. People use artificial intelligence all the time to create things. And that's the other thing in terms of like ownership, like that's sort of it's an interesting question in terms of who owns what, and I think that's sort of a question that that's sort of where the law is catching up as well. But I think I would essentially comes down to any creative relationship you enter into. I would put that in there if you're worried about that. Yeah,
that's great. Well, we are at the time for some questions now, and I do think we got to a lot that were in the chat, but some others that are standing out here, and please go ahead and drop any new ones that you might have. So here's one from Maria. Someone had expressed interest in adapting an essay that she had written into a short film, and she's asking if she should get a copyright on that first.
do you have well, I guess my question would be, do you have a contract with the publisher, and who owns it? Do you own the rights to that? And if you do, then yes, I would definitely register the copyright to it. Sometimes the publications have you assign your copyright to them and you don't own it. So I would hate for that to happen if that's the case. But that's essentially what you would need to do. Yes, I would register.
Excellent. And we do have a number of individuals that are either writing for a book that will be published in the US, but they're not present. What are international considerations around copyright and publishing that we should be mindful of?
It's so different.
Mhm.
So I'm only licensed in the US. I can really only speak to US matters, but generally speaking, you publish all over the globe. But essentially you're publishing with the company in the US. It's likely under US law. But this goes towards, it's actually a really good point though, because it goes towards, in your contract you have representations and warranties. Representation is a fact, and warranty is a promise that those specific representations will be true into the future. And it's like a laundry list of things. Sometimes they put in there that it will, what you have written is, there's no unlawful matter, whatsoever. And you're like, well, what does that even mean? That could potentially be, that could potentially bring out, laws from around the world outside of the US. So that's why I try to strike things like that. So I wish I could give more guidance to how it's treated internationally. I mean, there are treaties, there are certain things, certain benefits that all authors will benefit from by the US being a part of these international treaties. But in terms of the individual copyright law, it's a little different. Like, for instance, like Canada, UK, they have like fair dealing, which is a little different than fair use. I know the UK libel laws are more stringent than the US. So I would just say, if you plan on publishing in those countries, I would hire an attorney in that country to help as well.
Okay. One question that oh, sorry, David, go ahead.
I was going to ask Joe a question. So any author who's uploading their book, US based author, and they're selling that book in the UK, because it's for sale in the Amazon UK store, does that make a difference?
Possibly. I mean, I haven't seen anything like that.
Either,
But yeah, possibly. Yeah, I would say I guess it all depends on the the reader, right? And if they think somebody to defame them, or right of privacy, or copyright infringement. So yeah, it's possible, but I haven't seen it yet. Yeah, in my own experience.
I think especially for the independent author, this is a great question. Maybe both of you can weigh in on here. Are there any specific terms or additions to an agreement that authors should have when it comes to their collaborator? So this would be with illustrators, with editors, just some flags maybe that you've seen working against authors, or just not having the knowledge to ask for certain areas.
There are a number of things that you should put in your agreement. Of course, how much you're paying the person, or how much you're what's the split. Who owns it's going to be a joint work. I assume it would be you put that in there, that you would both own the copyright. This is for a collaboration. Then we'll get into the other thing I'm about to speak about. Then you want to look at who approves the work. What happens if either one of you get into an issue in terms of you don't like an illustration, or you don't like this chapter. And what I try to do is say, like, okay, if you're going with, like, say, if I'm like a literary agent, I'll say, well, I'll be the arbiter of that. And then if it goes beyond that, if you have a contract, then it should be the publisher. It just gets a little more tricky when it's self-publishing. So you have to figure out who is going to sort of give the final approval. Or maybe you could say something like, after 3 times, you haven't disagreed, you still disagree. Maybe what you have, that's what you're going to go forward with. I don't know, but you'd have to figure it out. So those little things. Arbitration, what type of, granted 99% of this doesn't actually ever happen, but what type of dispute resolution would you have if there's ever an issue between the two of you? Would you go to court? Would you go to arbitration? I would say go to arbitration, because it's less expensive, it's a good time saver. So those are some things that people may not have thought about in terms of their collaboration. And then on the other side of that is, if you're hiring somebody, make sure it's a work for hire, that you own the rights to it, and that you're able to use it in whatever way you want to.
Yeah, I could add a few things as well. I think knowing who owns those files ultimately, or that everybody gets access to those, spelling that out. I mean,
Yes.
essentially what you're talking about is, a partnership agreement,
Mhm.
and kind of looking at how, whether it's real estate or whether it's a book, there's certain, things you need to think through about that, and who has those final approvals, as Joe said, on it. The other thing, a very practical thing, is when you're working on if you're jointly producing a book like that, is who's going to be managing that account that you're selling it under. And so you can't really, it's good, the money's going to be deposited into one bank account, and who owns that bank account, and who has to be reporting that information, or do you both own that? Kind of thinking through that, actually, that whole sales part of it, and account management too. So there's a few, Publish Drive is one where you can have multiple authors share in that. I think Draft to Digital has something like that. You get KDP, you can't do that, so you just have a single account owner. That's a pretty important thing, because it involves money with what you're doing. So
Yep. Yep. And the other thing too that I would mention is credit. Believe it or not, it can be very problematic. So just make sure that if you figure out whose name is going to be first, whose name is going to be second. Is it going to be and? Is it going to be with? Is someone's name going to be on the bottom? Is it going to be on the top? And I've dealt with it where it was almost a deal breaker for one of my books as an agent. They figured it out, but I was like, you got to be kidding me! Like, out of all the things that could go wrong. But anyway, that's just to say, make sure you do your due diligence. I think that's sort of the lesson with all of this, right? Just do your due diligence before you actually publish the final product in all of this.
I had a funny situation. This is several years ago, where someone, it was I don't remember. They had a collaborator of some sort, and their name was listed in. So you can enter in the collaborator names in your accounts, like KDP, and that person's name was there along with their name, and they didn't realize it showed up underneath the title of the book, and they weren't really a material contributor to it. So they said, please take that name out. It was like, oh, okay. But it was a very simple thing, and it's just the way that some of the stores display this information now. You have to really consider that. And what if you're a contributor to it, an illustrator, let's say you're a children's book illustrator, you may want to say, I want to be credited in the public presentation and sale of my book. And, here's how I want to do that. In fact, it's a legal requirement when you're uploading files to Audible or Findaway, ACX, I should say, or Findaway, who is the narrator for that work. So that actually has to be named. They need to get that credit, and you need to ask that person, how would you like to be named with it? So it's a very kind of a practical matter.
Yeah, and if I could just pick, that's a very, very good point. Just reminded me as well that, in terms of the money involved in whatever agreement you're in, figure out the type of deal that you want. Are you going in this 50-50? I've seen so many different types. Somebody will take the advance and the other person gets the royalties, or this person gets up, the first $10,000 and the other person gets the rest. So just figure out sort of what is best for both of you.
And I imagine those would be really important factors to safeguard the future of the book as well, when it comes to any potential reprints or, reproduction of the book.
Definitely.
Yeah. There's a couple variations of this question in the chat, but if individuals are doing one-on-one interviews, whether it's with a public figure or individually, are they able to use quotes from that interview? Should they have someone sign a contract before conducting that interview for safeguarding the content they're about to receive?
I mean, best practice is to have them sign a release. Some people won't do that, and so maybe you can just ask them for their oral consent. It's better than nothing. So you could say, and then you can use it.
Okay.
And my practical contribution to that too is make sure you're giving the attribution accurately in the way that person would like to be attributed to that, and don't change that. So whether that's you're doing blurbs, or if it was an interview, how would you feel if you were being interviewed and that person used that and didn't ask you, whether it's whether it's for permission, or whether it's how would you like to be credited with it too. So I think that's a really critical thing, just because it gets back to relationships.
That's a really good point.
Well, Joseph and David, do you have anything else to add today? I think we got through a lot of our questions. As I mentioned, we'll be sending out a recording of the webinar to all who registered. We do have some questions, I guess, that we didn't fully get through, but I think they're a bit more specific. So if anyone has anything else to drop in, or Joe and David, anything to part with here, we're about ready to wrap.
Sure. I mean, I would, like I mentioned before, it's all one big risk analysis. Do your due diligence before you publish the final product, and you will be so happy that you did that. That you won't have to go into most of these issues that we're talking about today. And that goes towards as well, if you're traditionally publishing, make sure you get the permissions that you need, rather than waiting for the last second, because you're going to be working on your book and focusing on that rather than the copyright permission. So essentially, if I could counsel anybody, I would say do everything sort of backwards, where make sure you get the things that you need that are extraneous to the book, and then go ahead and write the book. If you could, best practice, I'd say.
One thing I'd add that I see a lot of is make sure you get things in writing. It's so easy to do things with email, and we deal a lot with people who are republishing books, or would like, maybe their publisher went out of business, maybe they got a reversion, maybe there was some other kind of, I don't know, there's a problem, they broke up with their co-writer, whatever it is. Get it in writing, make sure there's a signature on it, put it in the file, because sometimes it's not just a legal matter. Amazon's kind of judge and jury these days with a lot of things. And if they say you can't publish that, or you need to prove that you have the ownership to it, you can't just send them an email. And this has happened to us repeatedly. You want to send them a letter that is signed off on by the former rights holders, or whatever it might be, that you have that permission, whether it's even to use a book cover. So I think having that kind of on paper with a signature in whatever you're doing, your partnership agreement or anything else, that's just, don't rely on the verbal, don't rely on the email or a text message.
Yep, exactly.
Excellent. Well, Joe and David, thank you so much for joining. We'll include your contact information with the follow-up link as well.
Sure, it'd be great.
All right.
Thanks for having me.
Thanks all.
Thank you so much. Appreciate it. Thanks,
Bye
everybody.
now.